Are you on supposed to be here for 9:30?
Nope, nothing starts here at 9:30 ever. That's okay. All right, sir. I'll recall, obviously, the bond forfeiture. And so, Mr. Van Wright, you were previously in court and entered pleas of true in a motion to revoke your probation and entered plea of guilty in the new offense. Can you send me that paperwork just because this is all... And the agreement was for a 2 years TDC, and I gave you a little bit of time to come back and be sentenced today, correct? Were you arrested for anything between that time and now?
No.
So if they were agreed, I should have these printed out. We shouldn't have these if they were agreed. There they are. Put that away. All right, and give me just a second. Sorry, I'm a little out of sorts. What did he plead true to?
There's only one count.
Okay.
And
And then change it. Got it. All right, Mr. Van Wright, in cause number 24 DCCR 2485, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 15-23582, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find sufficient evidence in that case to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on...
This is a huge legal turning point. The sentences running concurrently means the defendant serves both cases at the same time, not back-to-back. That's a big win compared to consecutive sentences. But here's the trade-off. Notice the judge clearly states the right to appeal is waived. So the agreement gives certainty, but it closes the door on challenging this later. Would you take guaranteed time now, or risk more later for a chance at appeal?
Credit on that for any time that you've been in custody that the law gives you the right to receive. The cases will run concurrently, which means together at the same time. I'm handing you, in each of those cases, trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can speak with your attorneys. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Simmons. Oh, I don't see that paperwork yet.
Okay.
Clifford Norman,
I'm sorry, Judge. I haven't gotten to that.
just have a seat. I'll recall it in just a minute.
He can come up and talk to him. Mr. Norman.
What about Drayden Rose? Is there paperwork on him? I'll hold it. As soon as it comes through, I'll recall both of those.
Now, we shift gears completely. New defendant, new charge, and a very serious one. Unlawful possession of a firearm by a felon is not minor, especially in Texas. What's interesting here is how quickly this moves toward trial instead of negotiation. When a judge says no plea agreements unless something drastic changes, that's pressure. The video evidence mentioned, that could make or break everything. Question for you. If you were the defendant, would you push for trial or look for a deal before that video plays?
Mr. Kimler, you've got Ronald Souls.
He's trying to use
And this is Ms. Malfino on Ronald Souls. Good morning, you're Ronald Souls. And in cause number 25, DCCR 0252, Mr. Souls, you're charged with unlawful possession of a firearm by felon. Case is set for trial to begin with jury selection on Monday, January 5th. What is the announcement?
Brady, Your Honor, I did file a motion to suppress, which I think we can carry with the trial. I don't know if it's going to show up yet. I did that over.
No, it's not here yet.
We can carry it with the trial.
Ms. Malfino?
I haven't seen it yet, but I'm ready. I just have one officer in that case.
It's just a warrantless, standard warrantless search.
All right, so I'm going to number the case. Obviously, everybody knows after today, no plea agreements unless something changes drastically with any information that you guys don't already have. Stay in touch with Mr. Kimler. You'll need to be back Monday, the 5th, at 1 o'clock. He'll know that for sure tomorrow, though, okay?
I think, Judge, if I may, there is a video, and I appreciated the defendant look at it before.
Have you seen the video?
No, ma'am, Your Honor, I wanted to bring this up to the court's attention. I'm from Lake Charles, Calcasieu Parish. I don't know if the courthouse, that I'm not from down here. And
I don't care where you're from.
yes, ma'am, I'm just,
I mean, it really, I don't mean that mean, but it really doesn't matter. You're still going to be required to be back here for your trial.
yes, ma'am.
So, but what I'd like to do is, do you have
And then
that?
I can go upstairs and get it, Judge, and in light of that, Mr. Kimler and I might be able
We
to
can work
have a
it out.
short conversation.
Do you have time to use,
Yes,
we can
absolutely.
get a
Absolutely.
computer and y'all can sit in the jury room?
Absolutely.
Okay, have a seat until we get all that. We're going to let you and Mr. Kimler watch the video that the state's attorney has. If that changes anything, we'll see this morning. If not, we'll number it for trial. Don't leave, okay?
Just have
yes, ma'am.
You've got Richard Robb. It's a sentencing, Mr. Kimler.
He's already pled.
Richard Robb is set for sentencing. You should have a pre-sentence report.
Less than 3 days. Rob,
Oh,
sorry to
okay.
make sure I didn't. Yeah.
Oh, yeah, it was the lesser included, okay. All right, sir, you're Richard Robb, and this is 24 DCCR 2170. Mr. Robb was previously here, entered a plea of guilty to the lesser offense of a Class A misdemeanor theft of property, and I reset it for sentencing. The agreement's for 3 days in jail, and is there any reason not to go forward with sentencing?
Now that I'm aware.
Not from the defense, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor theft of property, sentence you in accordance with that agreement to a term of 3 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been incarcerated on this case. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.